and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Hello, Richard.
Hello, Lizzie. Cold day.
It is a cold day. Winter is set in. As it gets dark outside, we are going to start talking about a county court case from the 5th of November. And the case is called Ministry of Sound and British and Foreign Wharf Limited. And it is all about lease renewals under the 1954 Landlord and Tenant Act. So do you want to start with a bit of story time background for us?
Yeah, you know the Ministry of Sound, Lizzie.
Of course.
Do you?
I do know. Yeah, I do know what the Ministry of Sound is. I've not been.
It's a famous club and dance.
You go most weekends, don't you, Richard?
I do. I like to listen to the hit parade, and that's where I go. It's in Southwark in London, and it's the Ministry of Sound, and it's a famous venue. It's been around since 1991, but they've got a lease. The current lease is 15-year lease. There are actually three bodies besides British and Foreign Wharf Limited. British and Foreign Wharf seem to have a lease of the rear of the premises themselves, and they were subleasing. British and Foreign Wharf had a 99-year lease, but the front of the property was owned by, well, still the registered proprietors were the Mayor of the City of London. Earlier in this year, they'd transferred the freehold to somebody else, B&F Wharf Developments. And the current lease, as there was a 15-year lease, it was executed in March of 2011, but backdated to Michaelmas Day, 29th of September 2009. And so obviously it was up for coming to an end in 2024. But in October of 2023, the Ministry of Sound served a Section 26 request requesting a new lease. And they wanted a new 15-year lease. And parties can always agree whatever they want, but you're not supposed to get, if the parties object, longer than your original lease. And you shouldn't get more than 15 years unless you agree otherwise. Well, they wanted a 15-year lease, and the landlord was happy to give them a 15-year lease. But they were in dispute about various other terms. Most notably, the landlord wanted a break clause, so they could bring the lease to an end early, a redevelopment break if they managed to get planning permission for development, I think primarily residential development. And they wanted a rolling break as a consequence of that. And the leaseholders, the Ministry of Sound, objected to this. And that's some of the background.
So what did the judge say in this situation?
Well, I mean, they talked about several things, really. It's not sort of unique as a case. There's lots of cases over many years since the early days of the 54 Act on the issue of fixed-term tenancies with landlord redevelopment breaks in them. But they, firstly, they pointed out that it's a two-stage process to decide whether the landlord's got the prospect sometime in the next 15 years of development in exercising the break. Subjectively, they have to have a genuine intention to do so. I always remember an old 1950 case called Cunliffe and Governor, which is always quoted, Lord Chief Justice Asquith, where he said it wasn't actually about the 54 Act, it was about Section 18 of the 27 Landlord and Tenant Act. Most of the textbooks don't pick up on that, actually. But they said that it's got to be a genuine intention out of the zone of contemplation and into the valley of decision. If you remember that one, that's the kind of language.
I do.
That's the kind of language they use in the Ministry of Sound. They do seem to have had a potential genuine intention, but objectively they have to have a real chance, a real prospect. Would a person of business rely on the possibility of getting, in this case, planning permission? And there was a dispute between the various experts on either side, as you would expect. I mean, Ministry of Sound's experts were trying to argue that it's got to be a real probability, and that's not what the previous cases say. They say it's got to be a real possibility of getting planning permission, a real chance. I mean, I remember a case which wasn't actually quoted in 2018, Warwickshire Aviation and Littler, where the tenants tried to argue that it's going to be at least a third chance of getting ahead with planning permission. And the court basically said that's not so. It's got to be a real possibility. If you've got no possibility whatsoever, then you can't, you're going to fail. But they said in this particular case, they believe the experts for the British and Foreign Wharf Limited, there was a possibility of development. They'd been discussing potential development for 10 years, and there'd been residential development opposite in the recent past. So that the landlords succeeded on the need, if you like, the potential during the next 15 years to go ahead. But should you include a redevelopment break in the lease itself? And there's loads of cases, as I say. The first case I was aware of was in 1956, Rhearn and Barry Urban District Council in South Wales, where the court decided that the 54 Act shouldn't be allowed to stifle development. It's a balancing process between the tenants having security and the landlord going ahead with development. And there was a case, I remember, in 1990, probably the most important of all, National Car Parks and Paternoster Consortium. Do you remember that one? I've mentioned it in the past. It was the development of Paternoster Square, the square outside St. Paul's Cathedral. And St. Paul's Cathedral, as you can imagine, is a World Heritage Site. And any World Heritage Site benefits greatly from having a national car park next to it. I think it was an underground car park, and they wanted the 10-year lease. And the landlord, couldn't really oppose on ground F intention to demolish, reconstruct, because he wouldn't be ready for at least 2 years. And you have to sort of start the development within a reasonable time of the old lease coming to an end. It's 2 years because of the public inquiries and all the sort of extreme planning issues in relation to development. So the landlord successfully argued that we could have a 10-year lease, but the earliest which we might be ready to develop will be 2 years, so we can have a rolling break exercisable at any time after 2 years. And do you remember a case from a couple of years ago we did a podcast on? B&M?
Mm-hmm.
Was that on HSBC pension trustees, where, I think quite controversially, but the court allowed a break in favour of HSBC pension trustees with a pension fund who administer the pensions of HSBC staff and former staff. And the tenant got a 5-year lease, but the landlord could break it on notice at any time from day one, redevelopment break. And so on the basis of that case, on those cases and various other cases as well, there's Davies of London wine merchants and another one in the City of London, the landlord basically won. They got a rolling break exercisable at any time after June of 2028. So the tenant gets their 15-year lease, but the rolling break if they, get planning permission. They can deal with another thing, which none of the cases really do. But if you got a 54 Act protected lease and the landlord exercises a redevelopment break, then all you do is bring the 54 Act fixed term to an end, and the tenants on the face of it could stay anyway under a continuation tenancy. But what you can do is, there was a case, 1967, Shoal Manufacturing in Clifton Slimline, that you don't have to serve 2 notices. You don't have to serve the break notice and then a Section 25 notice, because the break notice can be a Section 25 notice if it's framed correctly. And you oppose a new lease on ground, presumably ground F, intention to demolish, reconstruct, or carry out substantial works. So there it is, another one which says there's a balancing process between the tenant having a degree of security and the landlord's being able to go ahead with the development if the prospects arise during the term of the lease. So there we are, Lizzie.
Thank you very much, Richard.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.